The next case on our docket is Petranek versus Salay. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. How long would you like to reserve?
Thank you, Your Honor. I would reserve 4 minutes for rebuttal.
I will be keeping time up here. I will let you know there's about a minute left in your initial time, just to give you a warning.
Okay.
If you go over a little bit, we'll take up your rebuttal. You can stop at that point, whatever you'd like to do.
Thank you, Your Honor. May it please the court, my name
Let me
is...
just,
Yep, I'm
I
sorry.
appreciate you ready to go, but
I'm ready.
we're still in your 2 minutes of waiting time. You're fine.
Okay.
The argument, just to let you know, the arguments are being recorded. So when you make your presentation, make sure you introduce yourself, number one. Make sure to stay there at the podium because the video will lose you if you wander from spot to spot. And also make sure you speak loud enough so that we can hear you when the recording picks you up. I don't think in this case there are any children, minors, or victims we need to concern ourselves with. If you have any concerns about that, please use initials or some other designated term for that. Having said that, we read your brief and are ready to proceed whenever you are.
Thank you, Your Honors. May it please the court, my name is David Cuppage. I represent Lucy and Steve Petranek, the plaintiffs and the appellants in this case. And with me today is Tyler Mahelko. Already indicated I'd like to reserve 4 minutes. I would start today by submitting this case should be reversed and remanded because the manifest weight of the evidence demonstrates that the Salays, the defendants in this case, retain control over the pond and the junction box, and therefore the Salays retain control over the diversion of the water, the amount of the water, and the concentration of the water that is being forcefully displaced onto the Petranek's property. Although the jury never got beyond the point of answering the question of whether there was a diversion of water, the verdict is against the manifest weight of the evidence based on the unreasonable amount of water being diverted and concentrated onto the Petranek's property. There's only one party to this litigation that controls the flow, diversion, and concentration of water, and only one party that can rectify the continuous trespass and nuisance that is being created. And that party, obviously, is the defendants. And frankly, preventing the diversion of water from the Petranek's property to, the Salays property to the Petranek's property was the main focus of this case. It wasn't, when you review the trial transcripts, the closing arguments, the presentation of evidence, and in particular, the questions that were being asked of the jury in the interrogatories, the question was the diversion of water. That was the first question. Actually, the first question was the question of whether the Petraneks owned the property. That was not disputed, and obviously the jury got that right. The second question that the jury was asked was whether there was a diversion of water from the Petranek's Salay's property to the Petranek's property. It is our position, and I believe that is where the jury lost its way. So when we talk about the verdict being against the manifest weight of the evidence, the question, the sole question, in my view, on that particular issue is whether there was a diversion of water from the Petranek's, the Salay's property to the Petranek's property. Because that's where the jury stopped its analysis. The interrogatories number 2, and I believe it was number 7, asked whether there was a diversion of water from the Salay's property to the Petranek's property. And the jury responded no, and that's when they stopped. So the question is that finding, is that answer to that interrogatory against the manifest weight of the evidence? I would submit that it is, in fact, against the manifest weight of the evidence. I would also submit that there wasn't any dispute whatsoever about whether there was a diversion of water from the Salay's property to the Petranek's property. There's really no dispute before the creation of this pond that the water slowly, gradually moved from the Salay's property to the Petranek's property all the way down to the Chippewa pond. The pond is constructed, it's maintained, it's controlled, and it's in existence, and its sole purpose is, aside from the aesthetics, is to take the water that previously gradually, slowly moved across the land, retain it, and by the way, move that discharge point about 125 feet from the east to the west, and put it into a 4-inch pipe. That 4-inch pipe led to a junction box, and that junction box wasn't maintained, it wasn't properly controlled. It was, in fact, in 2018, 2019, 2020, Mr. Salay tried to maintain it, to repair it, to fix it. It didn't solve the problem. So now you have water forcefully flowing through a 4-inch pipe in a concentrated, forceful manner, in an intense manner, and being forcefully placed onto and diverted onto the Petranek's property. There may have been a dispute about whether there was an unreasonable diversion of water, but the jury never got there. They never answered that question. They stopped when they determined that there was no diversion, no intentional diversion, and no diversion under the trespass interrogatory. So that's the question that's before this court on the manifest weight of the evidence. And there's really no dispute that a pond was built, that the pond retained water, and the water now flows out of a 4-inch pipe directly in one location under the Petranek's property. And there's really no dispute that it's causing flooding, it's causing erosion, it's causing sinkholes. There's really no dispute about that. I don't even think the experts argued about that. They talked about whether it was an unreasonable diversion, but not a diversion. So I would submit the jury lost its view, it's lost its way in answering interrogatories number 2 and 7. I would also submit that the trial court should have read all of the jury interrogatories. It failed to do so. I think that's plain there because the jury should have been told and instructed that they have a total of 9 interrogatories to read and review and to consider. And I think if they had gone through that, instead of just stopping at 2 and 7 and saying there's no diversion, they would have seen that the ultimate goal in this litigation was to prevent the continuing nuisance and continuing trespass. If you look at the interrogatories and if you look at the closing argument of counsel for the plaintiffs, he told them, if you find that the McKay remediation, what he was proposing, would prevent the nuisance and the trespass from continuing, you stop there. You answer yes, the judge issues an order ordering the McKay remediation report to be instituted, and that would solve the continuing nuisance and the trespass. So I think there's error in not reading those instructions. I think there's also error in directing a verdict on the qualified nuisance claim and instead instructing the jury that you have to find an intentional creation of a nuisance as opposed to a negligent creation of a nuisance. I think there was evidence of negligence, not just in the design and the construction of the pond itself, but in the maintenance of the pond, and the continuing maintenance of the pond. The fact of the matter is, in 2019, 2020, Mr. Salay must have recognized that there was a problem with the junction box because he went on to, well, it was his property, he went to the junction box, he attempted to make repairs. Didn't solve the problem. I think Lucy's testimony, I think McKay's testimony demonstrated that the problem just got worse. The sinkholes got worse. The erosion got worse. There was no solution to the continuing nuisance. There was no solution to the continuing trespass by just simply going and trying to fix, do some minor maintenance, fix and repairs to the junction box. The fix and the repair is to move the junction box 125 feet to the east so it's not diverting water continuing to divert water onto the Petranek's property, right past their house, right down, in some instances, within yards, mere yards of the house in the basement. So we would submit that the trial court erred. I think the first error was in granting the directed verdict motion on the qualified nuisance claim. Trial court should have then allowed the jury to consider qualified nuisance, whether there was negligence in this case, in terms of not just the construction, but the maintenance and the continued maintenance of the junction box and the pond. At the end of the day, however, I think the real question is with regard to the findings that there's no diversion of water. No diversion.
1 minute left.
Thank you, I appreciate that. I will end with that final thought. The fact that the jury came back and said there was no diversion of water in answer to interrogatory number 2 and 7 is clearly against the manifest weight of the evidence. This would be a harder case. I'll concede that. If the jury said, yes, there was a diversion, no, it was done, or yes, it was done without the permission of the Petraneks. And if we were arguing about whether it was reasonable or unreasonable, I would still take the position it was unreasonable. But here we didn't even, the jury didn't believe that. There was a diversion. It's clear. None of the experts disagreed. There was clear diversion, and the verdicts are against the manifest weight of the evidence. I'll reserve the rest of my time. Thank you.
Thank you. May it please the court, my name is Paul Ricard. I'm here today on behalf of the appellees Mike and Shelley Salay. To start where counsel left off, I think this court has been able to read the briefs and understands that our position is that there is a dispute as to whether there was a diversion, and that was the whole basis for the expert opinions rendered in this case, is that our expert said there was not a diversion. The appellant's expert said that there was. So we spent days painstakingly going over maps and plats, schematics. I'm sure the jury was so sick of seeing aerial views of Medina County because we went through all of the aerial views that we could find to show the jury what the course of water was flowing across the Petranek property before the pond was constructed. That was very, very important. And we showed the jury that there was a natural water course flowing across the property all the way down, forming a natural ravine, flowing all the way down to Chippewa Lake. And that had existed there likely since the glaciers carved up this area as they were receding back north after the Ice Age. So this is not a situation where the experts are agreeing that there is a diversion of water. Quite the opposite. The experts are very much disagreeing that there was a diversion of water. So because of this natural water course, Mr. Salay, back in the 1990s when he designed this pond, 27 years before the appellants moved in, he painstakingly went through the process of trying to calculate exactly where the original land was flowing across his property and the would-be Petranek property to figure out where his outlet for this pond should go. Before the pond, we had 3 acres of water. And whenever it rained, the water would collect on the 3 acres and it would all flow across his land down into this ravine down towards the lake. So when he designed the pond, he very meticulously and carefully selected the outlet point for the pond to match exactly where the water was flowing historically before the pond was ever constructed. Now, the jury heard this, they saw the maps, they heard the experts testify. Granted, there was a dispute between 2 experts. Our expert was from Medina County. He testified that he designed thousands of ponds over the course of his long career as a professional engineer. And he testified that the location of the pond was exactly, the location of the pond outlet was exactly where it was historically before the pond was built. And the pond did what ponds are supposed to do. It collects the water, a lot of the water evaporates off the top. Only when the water reaches a certain level will it then flow out this outlet point down into that ravine, down towards Chippewa Lake. He calculated and testified that the pond creates a 97% reduction in water flowing from the Salay property onto the Petranek property. 97%. That, again, it's doing what a pond is supposed to do. It's retaining water, it's evaporating water, and only releasing water when the pond reaches a certain level. So, I would argue that the jury got it right. If the jury believes our expert, and they believe in the work that Mr. Salay did prior to the construction of the pond, and they believe that the pond was placed in the right place, then of course they're going to find that there was no diversion of water, because they're going to agree that the outlet is flowing exactly where the historical water would have flowed if the pond had never been there to begin with.
Which is on the Petranek's property.
Correct. Yes, and there's no dispute. It flows out of the Salay pond, it flows across their property, flows across several other properties down towards Chippewa Lake. That's just the way water flows. We're out in a rural area. The Petranek's own 10 acres of land, rural land in Medina County. There's going to be natural waterways and water courses that flow across their property that don't make it an unreasonable use to construct a pond.
Counsel, isn't there some argument though about the concentration of the flow? The implications of that?
There were arguments during trial about the concentrations of the flow, and our expert testified that the flow, when it comes out of the junction box, is far, far reduced as to what it would be if the pond never existed. Again, that our expert testified it was 97% reduction in the amount of water that flows out of that junction box. So, Your Honors, this case really comes down to reasonable use. And essentially at trial, this was a battle of the experts. They had their expert, he testified that it was unreasonable. He testified that, as counsel just alluded to, that there was a diversion of water. Ours testified that the pond was reasonable and there wasn't a diversion of water. The jury took all the information back. They analyzed all the plats, all the documents, all the videos showing water flowing in various places, took all the testimony, and they came back and that they rendered a decision. So, based upon the totality of the evidence and the amount of evidence that this jury was subjected to over the course of a 3-day jury trial, it's completely within the bounds of reason that a jury would have reached this particular conclusion. To address several of the other issues raised by counsel in their brief, as we stated in our brief, it's not reversible error to not instruct a jury on all of the jury all the jury interrogatories. There's no requirement that a trial court has to read each and every single jury interrogatory to a jury in order for a jury to understand that they are to fill as many out as they deem fit. That's a Civil Rule 49B issue, that the court shall submit written interrogatories. Again, no issue, they be read out loud. The presumption in this case is in the finder of fact. And this court is to weigh the evidence and all reasonable inferences, consider the credibility of witnesses, and determine whether in resolving conflicts the jury clearly lost its way. If this court were to look at the record, look at the arguments, look at the plats, the maps, the evidence of the pre-flows and historic water flows, I believe this case clearly demonstrates that the jury did not lose its way. The jury got it right, and we would ask that this court affirm the underlying decision. Thank you.
You have your full 4 minutes for rebuttal, counsel.
Thank you, Your Honor. Rule 49 does in fact say that the court shall give such explanation or instructions as may be necessary to enable the jury to both make answers to interrogatories and to render a general verdict. So I do believe Rule 49 requires the judge to read the jury interrogatories. The judge stopped after interrogatory number 2. So there is error in not reading the interrogatories. Counsel for Applee said something that I think we kind of agree with, and he said this case comes down to reasonable use. I don't disagree with that, but it shouldn't have ended at no diversion, and that's where the jury ended this case. They found that there was no diversion of any water. And I think that is where the jury lost its way. I think that's where there's really no dispute, because frankly, there's a big difference between water gradually, slowly, naturally flowing from the Salay's property to the Petranek's property, as opposed to capturing all that water, holding it into a pond, and then having it forcefully sent through that pond through a 4-inch pipe onto the Petranek's property. There was a dispute, by the way, with respect to the amount of water that was being diverted to. By the way, McKay testified that there was 30% greater volume of water outletting into an area where it did not outlet into before, and that's at the record on page 464. So,
Counsel, why isn't this a case of just the obviously, or could be obviously a case of the jury just believe one expert over another?
Because the experts, there's no disagreement about how the pond was constructed, and there's no disagreement that prior to the pond it was a gradual flow of water, and there's no disagreement that after the pond, and continuing to this day, that the pond is diverting water into a 4-inch pipe and then forcefully ejecting that water into a singular location. That's a huge difference in terms of diverting the water from previous use to current use, and the intensity and the concentration and the flow from prior to what it is now. That's where this case, in my view, that's where this case comes down to. The experts could argue about reasonableness, and we can argue about reasonableness, but the jury stopped. They just ended the discussion, they ended the debate at interrogatories number 2 and I think it was 7, but they ended the debate at no diversion, and that's where I think they're wrong. And Your Honor, with that, I will conclude my arguments unless the court has any final questions.
I just wanna make sure I understand, are you saying that the diversion is, actually, or did your expert say the diversion is because it goes into the pipe and comes out forcefully?
He said that's part of it. I mean, he actually went beyond that, but that was one of the major opinions that he held. He also said that the outlet was moved 125 feet from the east to the west. So that's a big, significant difference. And he's saying, the expert is saying, put it back. Move the pipe 125 feet to the farthest easterly location on the Salay's property, and the problem is solved. That's the other, I think, the other major significant part of what our expert was saying. But also, the concentration was, the level and the concentration of the flow was a big part of what he was testified to. Thank you.
Thank you. The court will take the matter under advisement and will issue a decision in due course. That decision will be mailed to you by the clerk of courts upon the day of its release. It will also be available on the Ohio Supreme Court's website. On behalf of the court, I want to thank both of you for your presentations.
Thank you.